Have you ever wondered what would happen if you were suddenly unable to manage your finances or make important medical decisions? Most people assume that a spouse, adult child, or other close family member would automatically be able to step in and help. In reality, that is not always the case. Without the proper legal documents in place, family members may face delays, complications, and in some situations, court involvement before they can act on your behalf. This is where a power of attorney becomes important. A power of attorney is a legal document that allows you to authorize another person to act for you under specific circumstances. The person creating the document is often called the principal, while the person receiving authority is commonly called the agent or attorney in fact. Despite the name, a power of attorney does not require the person you choose to be a lawyer. It simply means you are granting someone the authority to handle certain matters on your behalf. For retirees and those approaching retirement, a power of attorney can be one of the most important planning documents you will ever create. Life can change unexpectedly because of illness, injury, hospitalization, or cognitive decline. Having the right person legally authorized to assist can help reduce stress and uncertainty for both you and your family. Many people focus on wills, trusts, and beneficiary designations when discussing estate planning. Those documents are certainly important, but they generally address what happens after death. A power of attorney is different because it can help protect you while you are still living. In this episode, we'll explain how powers of attorney work, the difference between financial and medical powers of attorney, common mistakes families make, and a simple checklist that can help you review your own planning. Understanding this document today may help your family avoid confusion tomorrow. Now that we've discussed why a power of attorney is important, let's take a closer look at what this document actually does. At its core, a power of attorney allows you to appoint someone you trust to act on your behalf. The authority granted can be broad or limited, depending on how the document is written and the laws of your state. For example, a power of attorney may allow an agent to pay bills, manage bank accounts, handle insurance matters, communicate with financial institutions, or sign documents when you are unable to do so yourself. One of the most important things to understand is that a power of attorney is generally created while you are mentally competent and capable of making decisions. In other words, it is a tool you put in place before it is needed. Many people mistakenly believe that a spouse or adult child can automatically take over financial responsibilities during a medical emergency. Financial institutions often require proper legal authority before discussing accounts or accepting instructions from another person. A properly executed power of attorney can help avoid those obstacles. You may also hear the term durable power of attorney. In many states, a durable power of attorney remains effective even if the person creating the document later becomes incapacitated. This feature is one reason why powers of attorney play such an important role in retirement and estate planning. However, a power of attorney is not unlimited. An agent has a legal responsibility to act in the best interests of the person who granted the authority. The document itself may also contain restrictions that limit what the agent can do. It's also important to remember that a power of attorney generally ends upon death. At that point, authority typically shifts to the executor, trustee, or other individuals designated under an estate plan. Understanding these basic principles can help families appreciate why a power of attorney is often considered an essential planning document rather than an optional one. One area that often creates confusion is the difference between a financial power of attorney and a medical power of attorney. Although the names sound similar, they serve very different purposes. A financial power of attorney generally authorizes someone to handle financial and legal matters on your behalf. Depending on the document and applicable state laws, this may include managing bank accounts, paying bills, handling investments, working with insurance companies, filing taxes, or dealing with property-related matters. A medical power of attorney, sometimes called a healthcare power of attorney or healthcare proxy, focuses on healthcare decisions. It allows a trusted individual to communicate with medical providers and make healthcare decisions if you are unable to do so yourself. Because these documents serve different functions, many people choose different individuals for each role. For example, an adult child who has strong financial skills may be well suited to manage financial matters. Another family member who is familiar with your healthcare wishes and comfortable communicating with doctors may be a better choice for medical decisions. The most important consideration is trust. Whoever you select may be called upon to make important decisions during stressful circumstances. Choosing someone who is responsible, dependable, and willing to serve is often more important than simply selecting the oldest child or closest relative. Communication is also critical. A power of attorney should never come as a surprise. Discussing your wishes in advance can help avoid misunderstandings and reduce family conflict if the document ever needs to be used. Many financial institutions and healthcare providers will also want copies of the appropriate documents before they can work with your designated agent. Keeping these documents organized and accessible can save valuable time during an emergency. Understanding the distinction between financial and medical powers of attorney is one of the most important steps in building a practical and effective estate plan. Even when people understand the importance of a power of attorney, several common mistakes can reduce its effectiveness. One of the most common mistakes is waiting too long. Many families begin discussing powers of attorney only after a medical crisis has occurred. Unfortunately, if a person is no longer mentally capable of understanding and signing legal documents, creating a valid power of attorney may no longer be possible. Planning ahead is often the best approach. Another common mistake is selecting the wrong agent. The person you choose should be trustworthy, responsible, organized, and willing to serve in the role. This decision should be based on ability and reliability rather than family expectations or birth order. A third mistake is failing to communicate your wishes. The people you select should understand your expectations and be comfortable carrying out their responsibilities. Open conversations today can prevent confusion and disagreements later. It's also important to review your documents periodically. Life changes, relationships change, financial circumstances change. A document that made sense 10 years ago may no longer reflect your current situation. To help simplify the process, consider this basic power of attorney checklist. First, identify who you trust to make financial decisions if you are unable to do so. Second, identify who you trust to make healthcare decisions on your behalf. Third, discuss your wishes with those individuals before naming them in any document. Fourth, work with qualified legal professionals to ensure documents comply with the laws of your state. And finally, store important documents in a secure location where trusted family members can locate them when needed. A power of attorney may never be used, but if the day comes when it is needed, having the right documents in place can save your family significant stress, time, and uncertainty. A power of attorney may not be the most discussed part of an estate plan, but it can be one of the most important. This document allows someone you trust to act on your behalf if you're unable to manage financial or healthcare decisions yourself. The key is planning ahead. Choose your agents carefully, communicate your wishes clearly, review your documents periodically, and ensure they comply with the laws of your state. While no one can predict the future, taking a few simple steps today may help your family avoid unnecessary stress and uncertainty later. Thank you for watching the Retirement Briefing. If you found this video helpful, please consider subscribing for more practical retirement and estate planning insights designed to help you make informed decisions with confidence.